Peter in Amersham. Peter, good evening. What's your question?
Good evening, Daniel. I'm calling about a Part 36 offer, and I'm asking about civil procedure rules with relation to Part 36 offers and whether it was sent with a genuine intention to resolve the dispute. The Part 36 offer came with the very first communication.
Well, Peter, just before you carry on, I'm so sorry. Let me just explain to everyone else listening what a Part 36 offer is. Part 36 of the Civil Procedure Rules is a special set of laws that encourages people to settle civil claims by saying that if either side makes an offer to settle and the other side fails to beat that offer, so for example, if a claimant says, I'll settle for 20,000, the defendant doesn't accept it and the claimant gets more, or the defendant offers 50,000, the claimant doesn't accept it but ends up getting less. If that happens, then the side who made the offer and succeeded in the litigation compared with the offer either gets extra costs, or the other side might get no costs, but it affects the legal costs of the action. Peter, I'm sorry I interrupted you. Carry on, please.
Well, that's perfect, actually, because you've helped me explain. So the issue is about whether the claim company had a genuine desire to settle because they asked for the maximum, which means you can't better that.
Okay, what type of claim is this?
It's a deposit protection claim.
So you're a landlord?
It's actually a friend of mine who's disabled, and the rent is their income. And they had a gap of just 12 days or 13 days where it was moved from an agent to the landlord and then back to the agent again. And during the statutory periodic tenancy, it was protected in the beginning. The claim firm has what I'm concerned about is that they've put the Part 36 offer in with the letter of claim rather than giving the letter of claim and giving the defendant a chance to respond to it.
Yeah, Peter, that's actually very common. In fact, it's encouraged by the courts. The earlier you put your Part 36 offer in, your offer to settle, the more courts smile upon you because they want matters resolved and they want litigation avoided by people settling claims. So I don't think your friend is going to get any truck by saying the other side offered to settle too early, even if the offer was pitched very high, indeed at the maximum that they could reasonably have hoped to have got.